Evicting a tenant in Kansas is never something that you want to do, but if it's what's necessary for your rental business, making sure you follow the right legal process is super important. If you try to evict a tenant for an invalid reason, or you lose the court case because of lack of evidence, you could face fines and may be forced to allow the tenant to remain inside the unit, which is something that we definitely don't want. And this can happen even if they violated their lease. Now, one thing we should say is that we're not lawyers, and the content in this video isn't legal advice, but we've created it to give you a good overview of the Kansas eviction laws and the process to help you get started with your eviction if you have to do so. With that being said, let's get into it. First things first, you have to have a legally valid reason for evicting a tenant in Kansas. If you have one of those reasons, you may or may not be required to give the tenant an opportunity to fix the problem before initiating the eviction process. And of course, this depends on your reason for needing to evict them. In Kansas, there are 3 main legal justifications that you can use to evict a tenant from your property. The first valid reason is to evict a tenant for a failure to pay rent. Rent is considered late in Kansas the day after it's due, but many lease agreements have grace periods that go beyond this. If the lease that you have with your tenant does have a grace period, you have to allow that to play out before taking action. If a tenant passes their grace period without paying the rent that they owe you, you can issue a 3-day notice to quit. This essentially tells the tenant that you've got 3 days to either pay the amount that's owed or vacate the property. Even if the tenant vacates the property at the end of that notice, you may still need to file eviction paperwork with the local court to legally process the unit, but this can vary based on your jurisdiction. The second valid reason for evicting a tenant in Kansas is a violation of the lease agreement. Even if a tenant has only violated one provision in the lease, they can still be evicted if the problem remains unfixed. Violations of the lease agreements can include conducting illegal activity on the property, damaging the rental unit severely, serious health or safety violations, having too many people live inside the unit, or keeping a pet in a pet-free unit. If you've got a tenant who you believe has violated their lease, then you can issue a 30-day notice to comply. This document gives the tenant 14 days to fix the lease violation. If the issue remains at the end of that grace period, the tenant will have to move out at the end of the 30-day notice. And if they don't, a landlord can begin the official eviction process with the courts. And finally, the last legally valid reason to evict a tenant in Kansas is a non-renewal of the lease agreement. This just means that you're not offering the tenant a new lease once their current lease expires. If you don't want to renew a tenant's lease, then you have to issue a notice of that before the lease expires. Now, the timing of this varies depending on the type of lease you've had with your tenant, but it often is either a 7-day notice to quit or a 30-day notice to quit. Now, month-to-month agreements typically have shorter notice windows, whereas long-term leases typically require more advanced notice. Now, if you've issued the correct notice and the tenant remains inside the rental unit after the time expires, you can begin the official eviction process and use a non-renewal of the lease as your justification. So once you're sure that you have a legally valid reason for evicting a tenant in Kansas, the next step is making sure you follow the correct legal process for doing so. Here are step-by-step instructions to help with that. First, you have to issue the proper notice to comply. The type of notice you need to offer varies depending on the reasons for the eviction and the provisions of the tenant's lease. But essentially, this notice to comply is often an opportunity for the tenant to do the right thing and fix the issue before escalating the matter to the courts. It's only after the tenant has missed their deadlines and shown that they're not going to comply with you that you begin filing your paperwork with the courts. After the notice is passed, the next step is to file a complaint. While filling out these forms and filing your complaint, you'll have the option to indicate any amounts and damages that are owed by the tenant. To file a complaint, the first thing you need to do is find the court that processes legal issues in your rental property's jurisdiction. Then you'll need to fill out the forms they request for the eviction complaints and pay the filing fees. Once you file the complaint, the tenant needs to be given a proper notice of the pending legal action against them. This is called serving process, and it's the next thing you need to do to complete an eviction. Now, serving process basically means giving the tenant a copy of the summons and complaints before the court date. But remember, you have to do it in one of these legally valid ways. Personal service is the first option. It means giving the documents to the tenant in person. Pretty self-explanatory. Substituted service comes next. This is giving the documents to someone who lives with the tenant. And if you can't use either of those options, posting and mailing service is your best bet. It involves posting the summons in a secure and visible position by the entrance of the tenant's rental unit and sending them a copy via first-class mail. And you do have one more option, which is mailing service. Now, this is a fallback option you can use if none of the other options are working. And what it basically breaks down to is sending the documents via certified mail and requesting a return receipt. Once the tenant has been served, you can file a motion to obtain judgment. And this just means that you're asking the judge to give you illegal possession of the tenant's unit on the basis of your allegations. The good news is that you'll win the case by default if the tenant doesn't show up for the court date, or if they offer no counter argument for your claims. But if they do try to fight the claim, you'll need to prove your case in order to win. Proving your eviction case takes evidence. Depending on your reason for the eviction, you may need to show things like copies of the lease agreement, rent receipts, bank statements, witness statements, and photo and video documentation. A hearing will be scheduled within 14 days of the initial hearing if the tenant wants to argue their case. This is when you'll present your evidence and when the judge will consider what the tenant has to say for themselves. And finally, once you win the case, all that's left to do is to regain possession of the unit. You'll now receive a writ of restitution, which allows you to do this. In Kansas, a writ of restitution gives the tenant 14 days to move out of the property. If they fail to do so by the deadline, they can be forcibly evicted, but only by law enforcement officers. If you try to evict a tenant forcibly on your own, or even shut off their utilities or try to get them to move out by force, you could face charges and fines that jeopardize your rental business. So that's it. We've covered everything you need to know about evicting a tenant in Kansas. No landlord wants to go through this process, but if you have to do so, make sure you follow these guidelines to avoid fines and penalties. If you need help organizing the kind of evidence that evictions may require, consider trying a free demo of DoorLoop. It's an all-in-one property management software that makes it easier for you to store, manage, and organize your tenant data. You can sign up for a zero-cost demo on our website today to learn more. But whatever you decide to do, we hope you found this video helpful. Don't forget to like and subscribe to see more videos just like this, and we'll see you in the next one. Until next time.